so probably got my butt in it. My name's Mike Baird. I'm a real estate attorney. I've been practicing now for about 14 years. And a little while ago, I noticed a pretty major change in what constitutes a writing. So we talk about it all the time that everything in real estate has to be in writing, right? But do we know why? Do we know what that really means? And it was interesting to me how the law kind of progresses based on technology and what's new and what trends are. And I thought this was a good example of that. So I put this little presentation together. And I like I said, I'm going to give you a link at the end, and I'll email people the link and stuff. So this is going to be more of a conversation. Don't feel like you have to memorize all this stuff. There's some legal stuff in here, but we're going to kind of make it real life. So the title of this presentation is, does that text bind my client? Wait, so you're the agent, you're acting on behalf of your buyer, seller, and you just put something in writing to the other agent who is acting on behalf of their buyer, who's your sort of counterpart, call it, in your negotiation. Whether or not that constitutes a writing has changed over the last probably 3 or 4 years. So we're going to talk a little bit about why when old law, and I threw the E in there on purpose, when old law meets new technology, okay? So this all started with the statute of frauds. The reason why everything for real estate has to be in writing is because of something called the statute of frauds. It's ye olde English law, enacted in 1677, saying that certain contracts, in order to be enforceable, have to be in writing, because some contracts can be verbal, right? And they're still valid or they're still enforceable. What is it that makes a contract legal, though? Who really cares? Like if I sign a contract to fix someone's windows and I say, yeah, I can do that. What's the enforcement of that, right? I'm either forced to fix the windows or I pay a penalty or something. Contract is something that the law provides a penalty for if you break your promise, basically, right? That's what a contract really is. So in order to be effective, some contracts have to be in writing because of the statute of frauds. Those contracts are a contract for more than the sale of $500 or more, for sale of goods $500 or more. Contract made in consideration of marriage, that's my favorite. So just to show you how old the law is, if I promise, I have a daughter, my friends have a son, right? If I promise, hey, she's going to marry Parker and you're going to inherit both of my dollars, then that contract has to be in writing for it to be valid. Well, actually, there's a $500 limit, so let's see about that. But the one that we care about is contract for the sale or transfer of an interest in land. Now, every single one of you is a professional, and you know that. So your offers are in writing, and your P&Ss are in writing, right? But the stuff that gets lost is those emails, right? Is that a writing or not? Those inspection items, how clear is it, right, in the offer, or how clear is it when we text it or email it or whatever. So we've been communicating that way for a long time, and a long time we've been operating under what's called a Singer standard, okay? And the court in the Singer standard basically said, I'm not going to read the jargon. It is far from obvious that average parties, blah, blah, blah. It is far from obvious that average parties launching emails at each other appreciate that their quickly composed electronic missives, $1 million word, are contractual in nature, okay? So the court basically said, at one point, the Singer standard was, for years, that the emails reveal, in many instances, the emails reveal that the parties are really just talking with the help of the internet and not sitting down across a virtual table to electronically write up a memorandum of any contractual significance. So the standard was, for years, that given how casual the interaction was, there's no way that anyone's actually thinking, hey, this is a writing, okay? Until 2016 rather, St. John's Holding versus Two Electronics. So this is a case that was decided in April of 2016 between these folks here. So Two Electronics LLC and St. John's Holding LLC. I condensed the letters of the parties to kind of protect, right? So the letter P is the manager. of the seller to Electronics. St. John's Holding is the buyer and is the manager, and we have the agents corresponding, okay? So that's gonna be important to kind of keep up with the fact pattern. So you'll see it. So, key facts and dates. In December 2015, St. John's Holding contracted these guys to lease the property. In January 2016, talks turned to discussion of purchase. Basic terms of the offer were outlined through in-person meetings, January 2016. January 27th, there's an email, a binding letter of intent from the buyer's agent on behalf of the potential buyer that contains specific terms such as the purchase price. Stop me when all this sounds familiar, okay? This is all gonna sound very familiar to everyone. There's a due diligence period, deposit, closing date. That was the first letter of interest, not signed by the buyer. The agent and the seller review and discuss the offer on the phone. On January 29th, buyer sends second LOI, also not signed, increasing the deposit. The listing agent informed the buyer's agent of the following concerns with the offer. A few things, they want them to pay $200,000 60 days after the closing, proposed due diligence is too long, typical stuff. On February 1st, here's where it gets interesting. February 1st, B sends an email stating that TE to Electronics is quote unquote ready to do this. But that P had 3 concerns about the LOI. The first, the matter, he would like to give you guys 3 weeks instead of 4. So the point is here, the listing agent doesn't really effectively say all of the concerns that the seller has. Okay, so that's key. Well, it's not that key, but it's important. February 2nd, we get an email attaching a 3rd written LOI. Okay, binding letter of intent. This is the final one, also not signed by the buyer. The only revision was that the date on which the final 200, so he tweaked one little thing, okay? The buyer's agent tweaked one little thing. None of the issues were raised from the February 1st email. So basically, the listing agent comes back and says, I don't like 3 things. The buyer's agent says, fine, we changed 1, okay? Meanwhile, also, see the little dots here? It's like way dramatic. Also, please indicate your agreement to the above summary of discussions by signing and returning a copy of this letter to the undersigned no later than February 4th, 2016. If you have any questions concerning the items to be addressed, please feel free to call. So this is the buyer's agent telling the listing agent, we have a time frame that I need you to agree to this stuff by and how we do it. There's an email with the final LOI received at 7:58 p.m., February 2nd, 2016. Meanwhile, also on February 2nd, 2 Electronics receives, wait for it, another offer. Another offer to purchase the subject property from a third party for a purchase price of $3,080,000. Higher than the other offer. I'm going to say significantly higher than the other offer. So, on February 3rd, seller's agent, this is the critical text. This is where we get into trouble, okay? The listing agent says, Steve, this is in a text. Listing agent to buyer's agent. It, blah, blah, to Electronics, wants you, St. John's Holding, to sign first with a check. Then he will sign. Normally the seller signs last or second, not trying to be stupid or contrary, but that is the way it normally works. Can Rick, who's the manager of the buyer, sign today and get it to me today? And this is crucial. 10. Okay? I don't know sociopaths that sign texts, but this guy did. Okay?
My mother does.
My kids make fun of mine are like grammatically correct. Yeah.
Oh, that's so cute.
Listing agent executes 4 original copies of the final LOI with the deposit check, gives it to deliver to the listing agent, to deliver to, for signature by the seller. Seller accepts third party's offer to buy the subject property, refuses to sign St. John's Holdings letter of intent. And off to court we go. St. John's Holding brings suit for specific performance. So in the contract language, the actual thing that the seller gets punished for is specific performance. So that's the the punishment or the consequence that the seller has. They have to actually sell the house. Okay.
To the first buyer.
I'm just saying, like generally speaking, when a buyer gets sued, they get sued for the deposit. When a seller gets sued, they get sued for a specific performance to do the thing that they're actually promising to do. Key questions. Does the text satisfy the statute of frauds that we talked about before? The fact that everything has to be in writing. Does the salutation Tim constitute a signature? First question, I know. It's like so this is the court now in the St. John's Holding case, okay? The writing need not be a formal contract, but the terms of the writing must be sufficiently complete and definite, and the writing must reflect a present intent of the parties at the time of the formation to be bound, okay? And yes, they do say bounds. Accordingly, the court held that the text message, together with the email and the final LOI, and the conduct of the parties throughout the course of negotiations satisfies the writing requirement. So the court determined that the communication indicated that the final LOI was received, made no additional changes to the terms, except as to the method of acceptance. So it's not like the listing agent pushed back and said, no, this isn't everything that we talked about. Basically took everything and just said, yeah, we're ready to do this, go ahead and sign me copies, basically laid out the methods of acceptance. Second question, it is established and reiterated that the signature of a duly authorized agent, rather than the party to be charged, is sufficient to be binding. The court relies on two factors when holding that a salutation Tim establishes a signature sufficient to constitute a signature. So yeah, it did. Regarding the Singer standard, so the court in St. John's Holding, who is now changing this standard, saying, because the Singer standard was, it's so casual, it could never be considered writing. The court is now saying that it is, and here's the reason. Singer was decided over a decade ago. Since then, the use of electronic communications, particularly in the legal field, has advanced immensely and become commonplace. Several more recent decisions acknowledge that emails may be writings to satisfy the statute of frauds and create a binding contract. So moving forward, okay, so that's the case right now. My suggestion is you guys should just stop doing what you're doing for work. Because now it's too stressful, right? So, this listing agent probably got sued by somebody, right? Because they didn't really put forward their client's interest or their intent, or they didn't know their client was gonna accept a third offer, or a second offer, so who knows? Moving forward, try to input some form of this language where necessary, and like I said, all this will be available, I'll give you the link, email link, or whatever. Upon receipt of any changes you may have, I will review the agreement with my client. Accordingly, I reserve the client's right to make further edits. I work that into all of my emails. When I send out a purchase and sale agreement to the buyer's attorney, and I say, when I get your edits back, I review it with my client, I reserve all the right to make further changes. Be aware of client's position with respect to terms. It's kind of a no-brainer, but you know. Final thought. Don't write a contract so it can be understood. Write it so it can't be misunderstood. So in an offer, right? In an offer, appliances. What's that?
What is it?
Yeah.
Washer, dryer, fridge.
Does it?
Well, I always say washer, dryer, fridge. And
Thank you.
Okay. It can't be misunderstood.
If it just says appliances, I always have to call and say, because I'm a really fun person to be around, I always have to call and say, which appliances? Does this include washer, dryer, refrigerator? Because it doesn't always. It says, oh, you know, appliances per MLS. That's something different. So make sure that it can't be misunderstood. Yeah? No,
So I think,
question.
so for me, the whole thing about this that makes this really relevant for us is not, I mean, is this, but it's not, we don't do a lot of the P&S and the contracts via email, but what we do is all this after conversations.
Exactly.
Like appliances, like, like, remember with what's his name on Sunrise, it was like, what about the closets are now gonna be done? And there were like 4 text messages and emails about, are there just gonna be bars or are there gonna be shelves? And we had, that was all decided via text message and email, because it was long after all the PNS stuff was done.
Yep.
And that went back and forth a lot, and I know that's the kind of stuff that I always get panicked about, because I've got a text message from me saying, yes, the seller will do this, or okay, the buyer agrees to this, and that's all post any contracts.
Yeah. So I had a situation where I had a buyer buying a place. He was living in Hong Kong at the time. Communicating with him was very difficult. We had to time it right, like 7 in the morning for him was 7 at night for me. So that's when we talked about a lot of the contract stuff. And he had an offer. It was like, he had an offer accepted. We were gonna sign the purchase and sale agreement, supposed to sign it that Friday. And communication was tough, so I said, listen, can we extend to the following Tuesday? The listing agent sends over an email and says, yes, that's fine. We can sign the purchase and sale agreement, Tuesday night at like 9 o'clock or whatever, because they knew that communication was difficult. The sellers were also traveling. That weekend, she got a higher offer for about $100,000, higher. And so they came back and said, oh no, you have to sign the purchase and sale agreement by Monday, otherwise we're done. And so
Because they wanted them out.
yeah, and they knew he would never be able to sign Monday. And I said, well, no, I'm sorry, we extended it to Tuesday. And they said, well, no, you didn't. These are the terms that the seller will accept. The buyer either signs by Monday or we're out of deal. I said, no, we're not out of a deal. Here's what we accept. And I actually just happened to do this presentation. And the seller's attorney said, can you please show me the case that says that the email extends the deadline? And I said, here it is. And so we extended the deadline, and my guy got the property, but he missed out on a pretty sizable closing cost credit that was never put in writing. So they talked about they were going to do, so as part of the deal, that it was like a $20,000 closing, because it's like a $1.5 million property. They were going to do like a $20,000 closing cost credit. That never made it into that deal, because they said, okay, fine, we'll move forward with the deal that we have. We're not going to give you the $20,000 closing cost credit. And my guy said, fine. But that wasn't put into writing. But the deadline extension was, yeah.
Don't both parties have to agree to make it binding? If one says, but I want it Tuesday, and the other says no, isn't that a stop?
No, because we had
They
already
had said
agreed.
yes.
So I said,
They had said yes to Tuesday.
yeah, I
And
said,
then they back
can we,
change their mind.
yeah, I said, can we extend the signing to Tuesday? And she said, yep, that's fine, and then try to change it. So, yeah,
But the key is that you were involved as the attorney.
Yeah.
If it had been the realtor,
Yep.
for the listing, the seller.
It was an email from the listing agent
Mhm.
saying that we're extending to Tuesday.
But if it had been the buyer's realtor that was doing all of this back and forth, just as you described earlier on with your presentation,
Yeah.
you were using realtors on both ends. It was all of their texting back and forth.
Yeah,
There weren't any attorneys involved.
nope,
That's
The
why.
key is, in this scenario you just given us, you as the attorney were involved in
Yeah.
that discussion.
But even if it was
Otherwise,
the
I think
realtors.
I think the realtor would have been lost, and there's no way that they would have had.
oh, then I sort of had
That
this.
they would have had that background that you had.
Yeah,
So I guess it does come back, what are we doing, writing up and putting in contract type information?
yeah, I mean, like I said, so I
would.
went, so that's kind of why I suggested, working in things like, just, try to work something into your email, and your email citation anyway, saying, there's nothing in this, emails shall be contractually binding, there's some protective language out there that some agents are using now. In email, in text, it's difficult. In text, don't sign it.
In text, I could have grabbed your phone though and written something, you can't prove who it's from.
Yeah, but I'm not wearing a robe,
So,
I'm
what was
sorry.
the original date? What was the original date that it got extended to? Was it supposed to be before the weekend, and they said, oh, let's make it Monday, let's make it Tuesday?
The original was Friday. We talked about extending it to Tuesday. They agreed to Tuesday.
See,
And then they got
weekends
it.
don't exist in real estate as far as I'm concerned, and I would never, time is still of the essence until that thing is signed.
Yeah.
I would never give them 3 days, it's like,
Because both parties were traveling. Both parties were outside the country. And they knew the buyer was living in Hong Kong, and we had trouble communicating, and we had been talking a lot since then, but yeah, usually you would not do a 5-day, no, I
No,
agree,
yeah.
usually it wouldn't be 5 days.
I've dealt with people out of the country and it's like, okay, 24 hours, when do you wanna get on the phone? I mean,
Yeah, this was,
7 o'clock,
You're a hard ass.
Huh? I am a hard ass.
Wow.
Cause look what, I mean,
Don't mess with
look
her.
at the mess it turned into.
so this will be on, this is going to be on, I'm gonna upload it to my website, massrealtylaw.com.
It's a great website.
Oh, thanks.
Sorry, can I say what, you said don't
Yeah, go
sign
ahead.
the text, on that last comment?
You know, I don't know if that's gonna solve everything,
That's what
you know what I
so
mean?
does that really matter if you're signed it?
Ah,
Just
hard
to
to
your
know.
point of saying how
It's hard to know.
But that was one of the things the judge had, said that it was signed.
Signed, so make sure you
yeah.
don't, okay.
So on this website that I'm having trouble negotiating right now, yeah, you recognize that. I've got a section here under agent resources. So, it's got some stuff here, I'm gonna basically download this, onto that section there. And, like I said, I can email you the link as well, but, any other questions before we find out who has this book?
I'm a little bit, we have a manager in our office, he's out today, it's too bad he didn't, because he is undeniably saying, folks, we're not in the business to write contract information.
Yeah.
That's
But
not our job, that's.
you are in a position as an agent to discuss terms. So
Discuss
that's what-
terms, but
that's what
putting
these
things
guys
in
were doing.
writing and things of that nature, I don't know.
But
It
that,
would seem to me as an attorney,
yeah,
you would come back to us and say, folks, you're in the real estate business, you're buying and selling. But when you start getting involved with different
But you're-
clauses and everything else, come to us. Come
But
to our
I
name.
think that's why what I brought up is, that's where we do a lot of, what's gonna be in the closets, or, which appliances are gonna be, a lot of that, which is typically conversations after the
Right,
contract.
right.
And that's very rarely
But
between
I'm
buyers.
talking about the purchase of the property, that's
Right.
one thing to do closets and things
Right,
of that nature.
right.
but
And
that
you mark it
offer,
up.
that offer that gets signed is a contract.
Oh, no, I
So,
understand,
yeah, so you're talking back and forth. About, honestly, it's kind of a questionable decision, right? Because, you're binding someone to make them sign an offer, right? They hadn't signed the offer, but you're binding them contractually to what their agent said that they would sign. So, I mean, like I said, you can make that argument, but the state of the law right now, this is the standard. And that's what was established. So I guess, the main thing is, it's like I say, your offer, you're always gonna have it nice and careful. Your P&S is, you're always gonna have it nice and careful. It's those communications in between to be concerned with.
When I would do things like, the buyer needs 3 more days to close, the seller, can you do this? Yes, okay, you agree. Can you just send me an email saying, I agree to
Yeah.
extend by 3
Always.
days, blah, blah, blah,
Always.
and I just print it
Yeah.
and put it in the folder,
Yeah,
and
I
then
even,
you're covered.
I do an email, oh yes, you are covered by email. I even do the belts and suspenders approach. I do an actual separate extension.
Right.
Yeah, but you don't always have time for that, and you're always sitting here to do that, and you wanna get it done quick, so. Unfortunately, these deals come together quickly, it's kind of the world we're all in. Any other questions? I know everyone's gotta get back to the day.
What about consideration,
Yeah.
isn't it? I mean, it used to be, the contract was,
Mhm.
a meeting of the minds, but there also had to be some consideration.
Consideration is simply a promise to do something you're not otherwise legally obligated to do.
Doesn't have to be a deposit check.
No. Consideration is basically, could be an act. Like if I make a contract with you, that I'm gonna do push-ups every morning, I'm gonna do push-ups every morning, or let's say I'm not gonna drink
And Mike,
alcohol.
it's working, by
Right?
the way.
If I
I
make a
don't see where I win on
if I write a
that.
contract, well, no, let's say that I have a contract with you. Let's say you think that I drink too much alcohol, right? Because I'm Irish Italian, okay? But we make a contract and you say, okay, I'm gonna give you $100 at the end of 30 days if you don't drink alcohol, okay? Well, what if I'm a Mormon? I'm not gonna drink alcohol anyway. That's not consideration for me, because it's not something I'm going to do anyway. Okay, so that's That's what consideration is. Consideration is just doing something you're not otherwise going to do. So, Two Electronics are already obligated to sell the property to St. John's Holding. That's their consideration,
Okay.
is selling it, is like doing something. Yeah, it doesn't have to be money.